Hi, I'm attorney Julie Hauf. We're going to continue our theme for February fee hearings all month long, such an important topic. So today I want to talk about one of the first things that I do when I have a new file as an expert or I have a file of my own. When I get the plaintiff's timesheets, I go straight to the docket and I print a copy of the docket and I put it down on the desk right next to that timesheet and I go through the two things together. There's a few different reasons that I do this. By putting the docket side by side with the timesheets, it helps you get a clearer picture of what happened in the case, especially if it's one you're an expert in that you didn't handle personally. You can see the page numbers on motions, so on most dockets that you get. So for example, if you have a 1.5 for some pleading that is only a 2-page pleading on the docket, you know right away that's going to be something that is problematic and ripe for reduction. Looking at gaps in time, looking at those dates, where there are lack of prosecution motions filed, where there are periods of time where there's no activity for 8, 9, 10 months, over a year, but on the docket, but then there's activity on that timesheet that doesn't really seem to be moving the case forward. There's research, there's drafting, there's making charts, but none of those things really advance the docket. So looking at and advance the case forward. So looking at that information on the docket, what's happening in real time versus what may or may not be happening on the plaintiff's desk, can again be a good indicator of what time should be awarded, what's reasonable, and whether the activity the plaintiff was undertaking really did move that case forward. Looking at cancellations, whether it's a cancellation of a hearing, a cancellation of a deposition, something else, looking at notices of unavailability. Do you have someone saying, oh, don't set any hearings, depositions, anything else in this file for this 2-week period, and then when you go back and look at the timesheets, you see that there's a ton of work during that time. That's something you certainly want to question the plaintiff about. Looking at transcripts. So if you've got a transcript on the docket, for a hearing, for a deposition, you want to look at the time and make sure that it matches up correctly. So for example, that deposition started at 11 o'clock, it went to 11:42, so that would be a 0.7. Did plaintiff bill a 1.9 for it? That may mean they included some travel time, it may mean they included a meeting with the client, but there's something in there, there's more information that you need to have. Attorneys shouldn't be billing for their travel time associated with attending something back when we attended things in person, which hopefully will be happening again soon. But again, looking at that time on the transcript is a great way to figure out whether the time the plaintiff put down for something is accurate. We'd also want to look at the number of pages of a transcript. So let's say that someone attends something, they attend a deposition, they get a copy of the transcript, and then they bill you an hour for looking at it. Well, if that timestamp on that deposition is only a half hour long, doesn't make sense that they spend an hour looking at it unless there are a lot of exhibits, but the plaintiff should really be specific in the timesheets to say that I looked at the deposition transcript, I also looked at the exhibits, they were this many pages. Otherwise, that's another type of entry that's ripe for reduction. Looking at the docket will also give you an idea of who was driving that file more, give you a sense of who filed more pleadings, who was really driving that litigation. Was it strong on the defense? Was the plaintiff just papering up that file with no real good reason in there? So this is good to find out as well as the expert or as the person that's handling your own fee hearing to get a good sense of what's happened in that file. Another thing you could look at is if there are some orders in the file and look at your judge, if it's still the current judge, to get a sense for whose side they were on for most of the file. Sometimes the judge will put some additional comments in an order that gives you a real clear picture that they were more favorable towards one side or the other. Maybe they didn't like the activity that the plaintiff or the defense counsel was engaging in during the litigation. So it's good to be watchful for that as well. The time from the filing to the settlement, if a settlement did occur rather than a verdict being entered or a judgment being awarded, that's something that can be helpful to figure out, well, okay, how long was this? Is this file open for 3 months and all of a sudden we have a $10,000 bill from plaintiff's counsel? That's not going to make sense. So having that docket side by side with the plaintiff's timesheets once you get them, it is the first step, one of the very first steps that I take when I'm reviewing these files, either as an expert or if it's my own fee hearing that I'm covering. So a few different things that you can get from the docket. It's always good to have your armor locked and loaded and ready to go when you're getting ready for battle on the fee hearings. So we've still got more fee hearing content to come for the rest of February, so stay tuned. Any questions, you know where to find us. Thanks so much.